Accra High Court has ordered the remand of former Signals Bureau Director Boahene for 7 working days to enable the Attorney General complete the preparation of his witness statements. His wife and the third accused person, Mildred Donko, meanwhile, are to remain on the existing bail terms. The decision follows an in-camera meeting this morning between the trial judge, defense and prosecution lawyers in the chambers of the judge. The Attorney General had praised the court to remand the former Signals Bureau boss on grounds that he is attempting to interfere with the investigations. I'll bring in now court correspondent Lord Edward, who's been covering the story. Lord, good afternoon. Tell us a bit more about the hearing today.
Right, Kemini. So like you mentioned earlier, when we got to court today, the accused persons, that is the former Signals Bureau Director, Boahene, his wife, Angela, the third accused person, Mildred Donko, they were all seated. And then to add that Mildred came with her little daughter. They were all in court. But then the prosecution, led by Deputy Attorney General, Dr. Justice Stremsai, he came with his lawyers. And then the defense part was led by Samuel Atta for the accused person. And they went in chambers and met presiding judge Eugene Nyante Nyedu. The meeting lasted for almost an hour, I should say. And then when they came out, the judge did not obviously disclose everything that happened in there, but he did say that the prosecution was arguing to get Boahene to be remanded for 2 weeks, citing that throughout the investigations, they have realized that Boahene has the potential to interfere with their witnesses and then, by and large, the investigations. But Samuel Atta objected to that fact, saying that that cannot be the case. And so he actually wanted his client to be Mildred and then his wife are also on bail and remain on bail. But Boahene has now been remanded for 7 working days after his lawyer, Samuel Atta, pleaded with the judge to reduce it because I indicated that the Attorney General wanted him to be remanded for 2 weeks for their investigation to continue. So we are back on May 13th for the Attorney General, the prosecution, to continue their investigation. But by that time, they should have filed all the witness statements. And so when we come on 13th, you see what the trial will look like then.
I see. Lord, what do we know about the whereabouts of Boahene at this time?
Right, so as we are still actually here outside the premises of the court because he's still pulled up upstairs with the lawyers and then the Yoko officials. On my right, I could show you, but then the Yoko cards are on standby. I understand that they are working the documents as far as the warrant for the remand is concerned. So they are still processing documents. When they are done, and then he will be transported to the Yoko office, which is where he's supposed to be remanded for the next 7 working days. And the key word here is 7 working days because, again, his lawyers wanted it to be just 7 days so that it would be just 5 days that he'd be in custody while the prosecution do their work.
I see. What did counsel of Boahene tell you after the decision?
Well, as I speak to you, Samuel Atta is still upstairs with the client and then the prosecution. The Deputy Attorney General has already left the premises, but the senior state attorney, A.C. Yanka, she actually spoke on behalf of the prosecution today because the Deputy Attorney General was not properly grouped, and so he delegated her to do the talking. They are still upstairs working on the documentation for the remand of Boahene. So after to Samuel Atta and then the other defense lawyers are still upstairs trying to work things out before his client is remanded into Yoko custody.
I see. Is there any knowledge of where he will be held until the next 7 working days?
So as far as we've been told, the judge indicated that he's supposed to be remanded at the Economic and Organized Crime Office, Yoko, for the next 7 working days as the investigations continue.
Very well. Lord, I appreciate the report and thank you so much. Now, the Africa Judicial Independence Fund says it is concerned about the lack of robustness in the constitutional framework governing the appointment and removal of judges, including the Chief Justice. According to the fund, in its current form, the framework leaves room for potential manipulation and undue political influence. Therefore, it requires urgent tightening and reforms to better safeguard judicial independence. AGIF also cautioned against the politicization of the judiciary amid calls for the removal of Ghana's Chief Justice. According to the fund, any decision regarding the Chief Justice's tenure must adhere to strictly to the constitutional process outlined in Article 146 of the Ghanaian Constitution. He added, reaching a decision regarding the current Chief Justice without tackling the deeper systemic causes of the current crisis will not resolve the challenges confronting Ghana's judiciary. It will only exacerbate them. It is therefore calling on all stakeholders to pursue reforms through deliberate, lawful and participatory processes that uphold the sanctity and independence of the judiciary. Let's look at more of those recommendations that AGIF is making, including transparent and merit-based judicial appointments, strengthening the independence and integrity of the Judicial Council, ensuring adequate resourcing and administrative autonomy of the judiciary, encouraging open public discourse on judicial accountability without undermining. Saeed Salahuddin is fund manager of the Africa Judicial Independence Fund. Saeed, I appreciate you talking to us. Good afternoon. But let's get into those concerns you are raising. What exactly is wrong with the current processes in appointing and firing judges?
Good afternoon to you and your cherished viewers. Before I get to your question, the Africa Judicial Independence Fund is an initiative of Afrobarometer. It is born out of the pressing need to address the numerous and complex challenges facing judicial systems across Africa. As you might be aware, Afrobarometer has been conducting studies for over 25 years now across the continent, and the Afrobarometer survey results continue to point to lack of trust in the judiciary. And to help strengthen judicial independence and accountability, Afrobarometer set up the Africa Judicial Independence Fund. And now to your question regarding the problems with the judicial systems in Ghana in particular, if you look at we are not really concerned about whether the act of removing the Chief Justice is legal or constitutional. We are not concerned about the constitutionality of the process. We are asking the question whether or not the current constitutional framework as it is promotes constitutionalism regarding the removal of the Chief Justice. If you look at the current process, it begins with a petition to the president. The question is, why should the petition be forwarded to the president? It could have been the case that the Constitution should have named a body responsible for adjudicating on such matters so that the petition could have been forwarded directly to that independent body that will determine whether or not there is a case to answer in the first place. But if you say that the petition, one arm of government, very important arm of government, the judiciary, which is clothed with powers of adjudication in all matters, you are saying that when it comes to the removal of no less a person than the Chief Justice of the Republic of Ghana, the petition goes to the president. And it doesn't end there. The president must act in consultation with the Council of State. You look at the process carefully, you realize that the president also has influence in the appointment of the members of the Council of State. So the process right from the beginning is subject to political manipulation. And the constitutional framework should have been such that issues regarding the removal of the Chief Justice should in the first place be handled by an independent body. and the president or the executive should play no role when it comes to the appointment, when it comes to the determination of whether or not there is a case answer.
I see. And so when you say you call for an independent body, what are you looking at?
So we are talking about, look at other jurisdictions. Look at the case of Kenya. There is also a process for removing justices of the Superior Court and from the Chief Justice. The president has no role. When it comes to Kenya, a body is set up. The Constitution has named a body. The composition of the body is known right from the word go. So if you have a petition regarding the removal of the Chief Justice, the petition ought to be forwarded to an independent body, and the Constitution should have spelled out the body, name the composition of the body, and the constitution of the body, rather than saying that the petition should be forwarded to the president, and the president acting in consultation with a council of state that the president has influence in terms of appointment, not in terms of their decision making. When it comes to the appointment of many of the members of the Council of State, the president nominees are in there. It means that if the president nominees are in there, those that the president appoints to sit in the Council of State are more likely to take decisions that will favor the president. So right from the word go, there ought to have been a body named, and not that the president now act in consultation with the same Council of State to set up an ad hoc committee. The composition of the committee should be predetermined and not left to the president to determine.
I mean, I hear you talk about the issue of trust, but also whether or not people will have displaced loyalty, not to the states, but to the presidency, who, as you have outlined, appoints members at the national level of the Council of State. But the question some would also ask is, why now? Why is Egypt talking about this now?
Egypt is not talking about this now. Maybe Egypt is coming to the limelight now. Egypt is working across Africa. We are working in DRC, Angola, Kenya, Senegal, Zimbabwe, and then Uganda, just to mention a few. We've conducted a landscape scan that talks about the state of judicial independence in Africa. And even if you look at our statement, we made reference to a public lecture that was organized in 2023. And the issue just goes beyond the removal of the current Chief Justice, but the lack of trust in the dwindling lack of trust in the judiciary, and the fact that we are not only talking about the appointment, but even about the removal, even the appointment process of justices of the superior and lower courts. The president, the executive should have no role to play. When it comes to promotion of judges, why should the president be the one to nominate people for promotion? What if the president does not like a particular judge? What happens to that judge? It means that he will not catch the eye of the president. And if we leave the framework as it is now, it will continue to be influenced by the executive, and then the confidence in the judiciary will continue to dwindle. And when the judiciary lacks confidence, I and you will not have faith to refer our matters to the judiciary for adjudication.
I see. So, I mean, thankfully, there's a CRC process ongoing at the moment. Has Egypt made any engagements yet with the committee?
Yes, thankfully, the chairperson for the committee that is looking into the constitutional review process is also a member of the advisory board of the Africa Judicial Independence Fund, Prof. KWESI. We work hand in hand with him, and we are ensuring that most of the issues that we have raised and others have raised will be featured in any recommendation that committee will be making to the presidency.
Very well.